David Stodard. I'm an attorney. I'm speaking to you from an office in Anderson, South Carolina. Often people who have an adverse outcome from a medical procedure or medical treatment have a question, do I have a medical malpractice case? Well, I'm going to talk about the three things that you absolutely must have to have a viable medical malpractice claim. The three elements that are absolutely essential for a medical malpractice claim are medical negligence, causation, and significant damages. Now let me talk a little bit about negligence. Negligence, the definition of negligence, is the failure to exercise the due care that an ordinary person would exercise under the same circumstances. Let me give you a couple of common examples. Car wrecks. One would be somebody runs a red light. Well, that would be negligence. They fail to exercise the due care that an ordinary person would exercise when going into an intersection. Or if you are not looking where you're going and you rear end the car in front of you, that would be another example of negligence. Let me briefly illustrate medical negligence with an example. Let's say a patient goes to see a doctor, he's got some symptoms. The doctor runs some tests and doesn't find anything wrong with the patient or says it's just a minor illness. The patient goes home, the symptoms continue, this goes on for months, perhaps 8 months. The patient goes back to another doctor and the doctor runs some more tests and finds that the patient has cancer and it's in the late stages of cancer. And the doctor says that's what the symptoms were when you went to see the other doctor. It was cancer all along. Failure to diagnose cancer. If a doctor has an opinion that given the test results and what the symptoms were, the first doctor was not negligent, any ordinary doctor could have missed that diagnosis, then that would not be medical negligence. You have to have a medical opinion stating that yes, the doctor was negligent in failing to diagnose the cancer. Now, how do you get this medical opinion that there's negligence? Well, sometimes when you're seeing another doctor, the doctor will say something like, the first doctor messed up, or the first doctor should have caught this, or the first doctor should have done something different. Usually, you have to find a lawyer who practices in the area of medical malpractice and have that lawyer get all of your medical records and send them to an expert witness, a doctor, who can review all the medical records and give a formal opinion that in this case there was negligence. Now, the second element that you must have in any case is causation. You have to have evidence or be able to prove that the negligence caused your damages, caused your symptoms, caused your medical impairment, caused the loss of quality of life that you're experiencing. Let me go back to that example of a failure to diagnose cancer. All right, let's say you do have a medical opinion that yes, the failure to diagnose was negligent. The second question is, this late stage of cancer that you're in, could that have been avoided had the diagnosis been made earlier, had you gotten earlier treatment? Now, if your medical expert says, well, it doesn't matter that the doctor failed to diagnose you, you would have reached this stage of cancer anyway, it would not have helped. It would not have had a different outcome. Well, in that case, the negligence would not have caused your damages. On the other hand, if your medical expert says, yes, there was negligence, and you would have had a different outcome without that negligence, this failure to diagnose, you would have had a better outcome, then you have evidence of damages. Both issues, medical negligence and causation, again, are medical questions that only a doctor can answer. A lawyer can suspect medical negligence. You, the patient, might suspect medical negligence, but you don't know whether you have a potential viable medical malpractice claim until you get that medical opinion that there was negligence, and the negligence is what caused the problems that you're experiencing. Now, the third thing that you must have for a viable medical malpractice case is very significant damages. Medical malpractice cases are very expensive for the lawyer to bring into court. Often the costs of bringing a medical malpractice case, and I'm not talking about the attorney's fees, I'm talking about costs and expenses to the attorney that the attorney has to spend in bringing the case to trial. And a lot of this is expert witness fees. But the costs often run $50,000, and it's not unusual for the cost of a medical malpractice case to run into $100,000 or more. For this reason, you can't be asking for $20,000 or $50,000 or even $100,000. Normally, your damages have to be significant enough that you can reasonably ask a jury for $500,000 or more. Some medical malpractice attorneys have a rule of thumb that unless the medical expenses caused by the negligence and or your lost wages caused by the negligence exceed $500,000, they won't even consider the case. So let me illustrate this with another example, and I've been doing failure to diagnose examples with cancer. Let's do a different type of failure to diagnose. Let's say you have a knee pain and you go to a doctor and he does an x-ray and decides, well, you have some ligament damage that'll resolve. He gives you some anti-inflammatories and perhaps some pain medication and says it'll get better. 6, 7, 8 months later, you still have the knee pain. You go back to another doctor who does an MRI and tells you have a torn ACL. You need surgery. Now, if after that surgery, the outcome is the same as it would have been had the diagnosis been made the first time, then really your only damages is the 6 to 8 months that you suffered with knee pain until you finally had the surgery. There was no different permanent outcome. In that kind of case, your damages may not be significant enough to make it economically feasible to have a medical malpractice case. Yes, you might have malpractice. Yes, the negligence may have caused some damages, but it was temporary damages. Normally, for it to have a viable medical malpractice case, the negligence has to have caused a permanent injury, a permanent medical impairment that you would not have had but for the negligence. Medical malpractice cases are among the most complicated and difficult of civil lawsuits. Normally, an attorney is going to have to go over your case with what we call a fine-tooth comb before they're willing to bring that case. If you think you may have a viable medical malpractice case, be patient finding an attorney. Attorneys that practice in this area of law are very choosy in what cases they bring. If you want to talk about medical malpractice further, feel free to call my office, or if you have other questions about medical malpractice or personal injury in general, visit my website. There's other information on my website that hopefully will be helpful.